Welcome back to another episode of the North Carolina Real Estate Show. I'm Tiffany Weber, your host, and I'm joined today by Erica Henson. She is an attorney at Thomas & Weber as well. And today I am excited to have her here so that she can talk about her experiences with this topic, which is buying a property where there is a tenant in possession. So welcome, Erica.
Thank you.
So I think there's a couple ways to think about buying a property with a tenant in possession. Often I feel like agents will forget. It's not like a regular closing. So what would your first question be if someone said, oh yeah, we've got this property that we're buying, there's a tenant in there, what do we need to do?
So the first question I might think about would be, do you want the tenant to stay or do you want the tenant to go before you buy the property?
Mm-hmm. Yeah, I agree with that. And if you want the tenant to go, you got to consider how you're going to make that happen. I know personally where I see the biggest issues come into play is when the tenant either didn't know they had to get out, they weren't notified, or they don't want to leave. So talk a little bit about what happens if the tenant doesn't want to leave.
Yeah, so if you take possession or you close on a property and the tenant doesn't leave, then you as the new owner of the property have to figure out how to deal with the tenant, how to get them out. And a lot of times that can lead to eviction proceedings, which can be very time consuming and costly and not very fun.
Yeah. So, I mean, if you're buying one of those properties that has a tenant in possession, you want them out, you're going to have some red flags of, okay, well, has the tenant been notified? Mr. or Mrs. Seller or entity seller, did you tell the tenant your time is up, you need to be out, and are you going to get out by the closing date? The other thing is make the seller be the person doing the evicting. You don't want to become the person that has to do the evicting. I understand every situation is different, but gosh, what a pain it might be didn't you had a weird situation recently where someone elected to close, keeping the tenant in possession, and it did not go well?
Sure. Yes. The buyer went ahead and closed on the property before the tenant was out. And then he ended up not being such a good tenant, so she needed to evict him. And unfortunately, she had to refinance the property in order to start that eviction process to make sure that she could, pay for legal advice, counsel to help get the tenant out properly.
Oh, that's such a pain. And I know buyers get really antsy, especially if they're like, okay, I want to live in this house. Obviously, I can't live in the house if there is a tenant there. So the lease is up. Let's just get them out. But then the tenant says, I'll be out, but I need a week. And the closing is before the end of that week is up. And the kind-hearted buyer says, I can make it a week. I really want this place. I just don't want any issues. I don't want to drag this out. Let's go ahead and close. And, they'll move out in a week and then we can move in. It doesn't always work like that. So, there's certainly nothing preventing you from contacting an attorney when you go under contract to try to draft the contract in such a way that makes the closing contingent upon the tenant vacating the property. I know, people are like, gosh, well, isn't that going to cost some money? Yes, but so is evicting. So do you want to pay to get an addendum drafted to the contract, or do you want to pay hourly to get the tenant out of the property? Sure. I don't know. People might think differently than I do, but I would rather just address it up front. Sure. That's just a huge mess. Now, the other thing is, what if they don't want the tenant out? Then what? What would a prudent agent have together and ready to provide to the closing attorney so that the closing can run smoothly? Do you have any ideas?
Sure. So I think some of the things that the agent would need to provide is a copy of the existing lease agreement or the rental agreement. That way the buyer can see, or the closing attorney can see, what the tenant is currently subject to and what the buyer would be subject to. Maybe a rent agreement, or how much the buyer is paying in rent. Are they up to date? Mm-hmm. Different things along the lines of what the lease or the rental agreement says.
Yep, I agree with all of that. It's much more simple when it's a single family home to do that, because there should just be a lease agreement in place with the buyer and you get a copy of that. And in addition to wanting to know what terms the parties are going to be bound by, it's going to matter for the closing statement too, because you've got to prorate the rent according to the day of closing, unless the parties have agreed otherwise, which would have to be in writing. But generally speaking, you're going to prorate the rent based on the day of closing. And then you also have to deal with the security deposits, if there are any. We've got a special rule in North Carolina. It's probably in other states too, but definitely here in North Carolina, that the security deposit has to be segregated from the rent. So it's like an attorney has a trust account. Well, as a landlord, you have essentially a trust account or an escrow account that you put your security deposits in. So that's got to be a line item on the closing, and it's got to transfer from the seller to the buyer, so buyer can do that. And one thing that you said made me think about, like, if it's not a residential property, like it's an apartment, a lot of times they'll call that, like, agents, you could say, can you give me a copy of the rent roll? That might be what the landlord calls it, because it'll say, all right, Sarah in apartment A pays $650 a month and she's paid through July. Bob in apartment B pays $700 and he's up to date. It's just a way to see what needs to be prorated, what needs to be collected, who's going to be able to get what money on the date of closing. So you're spot on with that.
And sometimes they can be sophisticated. We can see landlords who have sophisticated data on the rents, and then sometimes it's just a matter of a handwritten note about how much the rent is and where the tenant stands on the rental payment. So it doesn't always have to be some fancy document. It can sometimes be handwritten or a manual document.
Oh, I've seen the handwritten stuff, especially, I don't know what it is about the people that own the mobile home parks, but anytime they come into the office to close on these things, they're like sliding a piece of paper at me saying, all right, this is what, I don't know what it is, but it just seems to be like, that's how they keep their documents. Not all of them, but I'm just like envisioning a couple that I've done where I'm like, I'm glad you got the information. That's all. We'll take the information. Great. Now, on that topic, let's say you've got a tenant that there's not been a whole lot of documentation and you want to make sure that all the parties are clear about who owes what and through what date. Tell us about a tenant estoppel. What does that do and why does that benefit a buyer?
Sure. So a tenant estoppel letter or agreement is what the tenant would fill out or sign confirming the terms of their rental agreement, the monthly rent payment, when it's due. So the terms that tenant has agreed to. That way, in the future, when the buyer owns the property, that tenant can't come back and say, well, that's not what I agreed to. That letter in and of itself prevents the tenant from saying something along those lines.
Yeah, and I think I usually tell agents when they're like, what's an estoppel letter? We've never had to do one of those. I'm like, you'll want this. Think of, when you hear the word estoppel, kind of think of a stop sign. It's a way to, a stop sounds like stop sign or stop. So it stops that party from saying, no, that's not what I ever said. I said something else. So whatever they put down in the four corners of that document is what it really is. And it stops them from saying they had some other side agreement. So that's kind of like a silly little way to remember what it is and why it matters. Now, another thing that could be helpful and is not always required is a tenant notification letter. So tell us a little bit about those.
Yeah, so I've seen tenant notification letters go both ways. So sometimes the seller will go ahead and provide notification to the tenant that there's going to be that there is a buyer, so they'll have a new landlord at a certain defined date. And then I've seen it where the buyer will issue the letter after they close on the property to say, I am your new landlord. This is where you submit your rent payment to. This is how to contact me. But that notification letter is to confirm who the landlord is, when the rent is due, how much, where to make your payment, or management company information.
Yeah. And that is not something that, generally speaking, that's not something the attorney does. So, yes, the attorney could assist in that process of helping you get a form for that if you don't have it. But for the most part, especially if you're buying investment properties to the level where like, I got to send out the notice, you probably already have a letter for that. This is not a legal document. This is truly just a notification. Like, this is telling factual information. Here's where you send your payment. There's the address, blah, blah, blah. It doesn't have to be complicated. No. It's best practice, but it doesn't have to be earth-shattering.
And if there's a lender involved on the buyer side, sometimes the lender will require one or both the tenant notification letter or the tenant estoppel letter so that the lender knows that the tenant has been notified and that all the parties are aligned. So sometimes you'll see that request from the lenders, but not always.
Yeah, that's a good point. And then also depending on what contract you use, like your commercial offer to purchase is... There's really no such thing as a standard commercial offer to purchase when you're buying investment properties. Like, sure, there's one promulgated by certain entities in North Carolina, but most commercial offers to purchase are vastly different from one another. So sometimes they'll require that one or the other of the parties submit this. Like you said, sometimes it's the seller and that's done on the day of closing or before closing. Sometimes it's the buyer and it's done after closing. But you've got to look at whatever contract don't assume that it's just because you've done it this way in the past, that this is how it will be in the future. Same thing like on the estoppels, you might have a form that you've seen filled out, but the lender might say, no, we want it on our form. As long as it provides the correct information, it's not doing anything illegal, that's fine. On the topic of things that are best practice and not always done, assignment of leases. And this one is an important one because buying property is not cheap. You're paying for the property, you're paying for the fees for the attorney, you're paying for the ability to borrow the money if you're borrowing money. So they think that's just one more thing we have to do. Yeah, the lease is existing, but I don't want to do an assignment. Well, the assignment of lease is important because it's making sure that you as the new buyer are a party to that lease. If you own the property, but the lease is between the old seller, what happens if you have to sue to enforce the lease against the tenant and you're not a party to it? So the assignment of lease, again, does not have to be complicated, but is an important thing in kind of like tying a bow on the transaction to make sure all of the boxes are checked and that the buyer is going to have the right to enforce any agreements that the seller had with the tenant. You've seen some other ways to handle that too, rather than assignment. Sometimes they terminate or modify. So can you talk a little bit about the alternatives to assignment of leases?
Sure. So in some cases, the current seller or even the buyer wishes to terminate the lease that is effective as of the contract date. So they might have a termination agreement with the tenant or a modification agreement with the tenant, but the intent here is to make sure that all the parties to the contract are protected in the event that something should happen after the buyer closes. So that's what the intent is. You can go about it a couple different ways in order to make sure that everyone's on the same page.
Mm-hmm. And assuming that you're keeping that same tenant, you might say, well, why would I terminate? Well, there's a couple different ways to go about this. You can assign the existing lease if the terms are going to remain the same. So if you've got the same length of time, the same amount of money being paid per month, when would you want to terminate? Well, that to me is if you have a lease that's different than what's existing, like say you feel like the existing lease doesn't have complete enough terms, you want to be more clear about what the rights are of the parties, you could terminate the existing lease and enter into a new lease. Now, the other thing that you could do is modify the lease. Say you're happy with the terms contained or the substance of the document, but the tenant's going to pay a little bit more in rent. You could modify the lease with that respect. So that's why it's not just assignment. Assignments keep it the same. Terminate is when you want a new one, and then modify is if there's just like minor things. So there's a couple different ways to handle it, but as long as it's handled, we are happy.
And sometimes the seller, maybe they have a tenant that is month to month or something along those lines. They've notified the tenant, hey, this building or this, home is for sale. At some point, we're going to have to terminate. So sometimes it happens on the seller side. They go ahead and terminate with the tenant so that the property is vacant once the buyer takes possession.
Yeah, and similar to like when you want the tenant out, say the seller did provide that termination or the termination has been signed, then a prudent buyer would want the seller to be responsible to make sure that that's been completed before closing rather than taking on that responsibility themselves for sure. I made a list of like kind of some things that I wanted agents to know, and the only thing I have left to talk about is management companies. This is more so to figure out, all right, buyer, you're coming into this property, it's got a tenant, who is in charge of taking care of stuff? Who's collecting the money? Are you going to do that yourself, or do you want a management company to do it? And if the management company is already doing it, do you like that company? Do you want to continue with them? If you don't want to continue with them, does the agreement need to be terminated between the seller and the company? If you do want to continue, can you assign the agreement, or do you have to sign a new one? So that's more so of like, that kind of happens outside of our transaction, but it's something that the buyer needs to know and needs to be working on. So that's kind of like part of due diligence, is go chase down this information and figure out, what do we got to do about this management company? We're keeping it or not? And if we're keeping it, what paperwork do we have to do? If we're not, what paperwork do we have to do? You're doing paperwork either way. Sometimes people are happy to just continue at the same management company because it tends to be less paperwork, but you should do whatever feels right for, whatever your situation is. I think, buying investment property is smart game, and it's easy, especially on your first couple deals, to not be thinking about these things, or, treat it like you've treated all of your residential transactions where there was no tenant. But if you're ahead of this, you're going to look like a genius to your new investor client when you're like, by the way, your seller didn't necessarily keep the cleanest paperwork, so we're going to do this estoppel letter so that the tenants can't tell you, no, that's not what I pay, or I'm actually paid up when they weren't. We're going to make sure that we've got the leases assigned to you. You're going to look like a genius in front of that client. And isn't that what you want? I mean, that's what we want for you. I don't know. Do you have anything else? Because we can never talk about everything in the topic, but I feel like that's a pretty good overview of what to look out for.
Yeah, I think on the legal side, we've covered everything. The only thing I would add might be more on the practical side. Don't forget to remind your clients to change the locks.
Yeah.
I mean, you might think that the tenant is gone or something. They come back. You don't know how many keys they have. So I always remind people at closings to change the locks just to protect themselves.
Yeah, that's smart too. And then any keypads and reprogram that stuff. And yeah. I don't want to get all conspiracy theorists and be like, check for cameras, but the locks, that is such a good point. I'm so glad you brought that up. Well, I think that's it. So this has been another episode of the North Carolina Real Estate Show. I'm so happy that you joined us, Erica, and I can't wait to have you on more episodes in the future. If you guys are in the counties that we serve around Lake Norman, then, you have probably seen Erica's face in closings already, but if not, you can catch her on our social media. You can find her on our website. So, she's super smart. She probably knows the answers to the questions better than I do. So you can reach out to either of us if you have legal questions about closings, and hopefully we'll see you at Thomas and Weber soon. Bye, guys.